right, we will get started. It is now 4:05, and we are getting started with the general government meeting, subcommittee of the Springfield City Council. We will call this meeting to order. We have one item on the agenda, which is the City Council Public Speak Out. We are joined by two members of the committee, Councilor Jerry Martin and Councilor Victor Davila. I see online virtually we have Madam President, Councilor Whitfield, as well as Councilor LeVar Click Bruce. We're also joined here by Attorney Moore. And so my thought process is that we'll start with Madam President to introduce the item, and then we'll then turn the floor over to you, Attorney Moore, who I know have been working tirelessly on this particular issue. So, Madam President, if you have anything to say at the outset regarding this amendment to the rules, then we will turn it over to you first.
The amendment to the rules. Yes, I thought this was the, I'm sorry. I thought this was the public speak out for the Wilbraham Ave closing. So I did not prepare myself for this. I thought it was Wilbraham Ave closing, and I even gave people this link for it today. So that's my fault. But I'm going to turn it over to Attorney Moore since he's the one who cautioned me on not putting it to the city council for some particular reason. So Attorney Moore, thank you for that caution, and I'm going to turn it over to you.
So Attorney Moore, thank you, Madam President. Attorney Moore, if you could just give us an overview as to what the amendment to public speak out and to our rules, what it is that we're trying to do through this order. And then we'll certainly seek your advice on pros and cons.
I appreciate that, Mr. Chairman. Thank you, Madam President. Thank you. So the request came in from Madam President to look to put into effect a trial program to have public speak out enter into the regular agenda items of council. She kind of asked the department to look over a draft provision that she put together. We sort of reworked it a little bit to make it work for the council based on the rules that they have in place. So just kind of walking through it really quickly, there are two rules that would need to be addressed to implement the pilot program other than just the council itself ordering the program. One of the rules is the rule for public speak out itself. I believe that's Rule 3. That rule discusses the timing of the public speak out, and it's a simple sort of revision of that to, in this case, for suspend the rule, but ultimately you could just revise that rule to talk about public speak out being a part of the regular meeting as opposed to the way it currently reads. Rule 3 also includes some what we'll call like guardrails on the discussion of public speak out, which have been long-standing as far back as I've looked at the rules. I think that language has probably been in there. So some of that language is what I sort of flagged for further discussion, and I'll get into that in 2 seconds. But the other section was Section 5, and that's very procedural, where Section 5 lists out the exact order everything has to be put in for every meeting. We would slot in public speak out where the program kind of wanted it placed, which is, I think, before most of the business of the body, but right after a couple of things. So that's what the suspension of those two rules would be. And the order we're talking about essentially takes 90 days to take those rules in suspension, put into place this new program that we've listed out in the order. And if the council likes the program after 90 days, it could then take action to be more permanent. Or after 90 days, if it felt like it was, wasn't working out, everything would automatically go back to the way it was. So it really is, in all sense of the word, a pilot or a trial program. And Councilor, I think you would inquire before about pilot programs versus trial programs. And it's interesting because pilot programs, the term pilot is used in a couple capacities. And I didn't really realize that until I started really working here, that pilot refers to taxation in many ways, the way we think about it. But it's also sort of kind of used as a generic business term for a trial program. Right. And that's really what this is. It's we're doing a test program, test pilot program. It's kind of where it comes from. So The one legal issue I saw with what we were talking about doing, it kind of comes down to walking the fine line between allowing the full rights of the First Amendment and Articles 16 and 19 of the Mass Declaration of Rights, which is essentially free speech and free assembly, allowing that to take place as it's supposed to. And then there's the balancing act of council's obligation under the open meeting law and under its requirements under the public hearing regulations about what it can and can't deliberate. So I looked at a lot of different towns and communities to see who was doing what with this, because this is a very common thing, as you might expect. And as you might expect, it was all over the map, Council. So, for example, it ran the gamut. Northampton is a good example of they have it within their meeting and it's wide open. There's no restriction. It is in the meeting. It is open to any subjects whatsoever. A hybrid of that, let's see, what was the hybrid one? It was City of Worcester. So Worcester has it in the meeting, but it's restricted only to the items on that agenda for that specific meeting. And then another example of another extreme would be Lowell, which does not have it. So they just don't do it. And maybe there's another form in which they engage the public and speak up, but it does not happen at the council meetings. So it really is sort of something that communities have dealt with on a case-by-case basis. And I kind of took that into consideration when I was thinking about what the council wanted to do here. The language in Rule 3 that I kind of looked at with an eye towards the First Amendment concerns was the language that talks about, I think it's restricting the public commentary to business of the city. And then it was also that any business that was a part of a public hearing could not be considered in the public hearing and wouldn't be, a part of public speak out. And looking at, both of those provisions, neither one of them raised giant red flags for me, where if we kept them in place, I would be worried about us getting challenged. I mean, they're already in place in our public speak out. That already is at a public meeting of the city council. So it's not, the difference in putting it within an agenda versus not an agenda. The language is still in our rules. It's been there for a long time. So, in many ways, I think it reflects sort of past council's approach to trying to make a reasonable restriction, which is allowable under First Amendment and Mass Declaration of Rights requirements. And most of those are like time, manner, place type stuff. Like you would think it's only a half hour. You got 3 minutes to speak each. It's going to be at this location and that's it. That kind of stuff is all allowable under First Amendment. But when it gets to content or it's sort of limiting political philosophy, then you start to get into the realm of not allowable prohibitions. And for us, it's kind of like, it's business of the city. Is that a reasonable requirement that we make our residents and our citizens adhere to during public speak out? I think it probably is. So I kept it, I preserved it. Is the same thing about public, hearings, information involving public hearings. Is that reasonable? We have a legitimate interest in adhering to the regulations attached to public hearings. It is reasonable for us to say we can't consider stuff that's about pending public hearing and public speak out. So I think both of those terms are okay. But I do think that the council has the opportunity in the trial program to consider other avenues. And that's kind of why I brought it up, is that there are other ways to kind of skin the cat, so to speak, here. The council could look at it and go, we want to make it wide open to the public. We want to make it content sort of neutral. If you want to, as an example, if you want to come to us on something that's not strictly city business, like say there's something going on at the state level, say there's something going on at the federal level, and you really want to talk to your local representative here to say, I would like the Springfield City Council to go on record about this issue. We feel strongly in our community about this. I know it's happening at the federal level. Pick whatever issue it is. Could be an issue about foreign relations or something, where the city has literally no role in that. But the citizens, you could argue have a right to talk about that to their representatives. And that's kind of why I brought it up and why I thought it was worth discussion, is that, it's not that what we're doing is wrong and somehow unlawful. I don't think that. I think there are other opportunities for us to open up the public engagement to potentially something bigger. And then with that, of course, comes kind of that fine line we're walking, where the more wide open we make it, the more we'll have to be diligent in the way the council itself handles the information. Not deliberating on items that aren't on the agenda is kind of a simple one for us to try to adhere to, but it's maybe easier said than done at times. I can very much envision a scenario in public speak out where a member of the community steps forward to the podium, makes this complaint about something that's important to a city councilor, and the councilor at that point probably want to respond, but if it's not on the agenda, how is that going to happen under the open meeting law? And so, you know what I mean? It becomes this sort of exercise in, okay, you know, should we open it to everything? We are opening the door to having to police ourselves more about how much deliberation we can actually do about anything that's said in a public speak out. And again, it's sometimes easier said than done. Like in the moment when it happens, it's going to be very difficult, I think, for all the counselors. If it's an issue of close to their heart or something constituents are constantly telling them they really want done, and someone stands up and is taking an opposing point of view, it kind of goes unanswered in public speak out. And if it's not on a meeting agenda, there's no opportunity at that moment for the counselor to then rebut what's been said. So it's not completely different than what happens now. But again, what happens now is it's all happening before the meeting. So in many ways, the council's they're bound to do what's on the meeting agenda. So if somebody says something in public speak out that's not related to the agenda, the council's not allowed to say anything now anyways. So it's the changes that you're doing it in the middle of the meeting. Do you know what I mean, Councilor? Does that make sense?
Somewhat. I guess I'm not understanding the difference in terms of what it is that we do now. I mean, even now in public speak out, if it was a matter related to, let's say, a hearing, you know, that we ultimately were going to deliberate on, then we couldn't talk about it anyway.
Right.
But when you start talking about the affairs of the city of Springfield, I guess I'm just not concerned. I mean, I'm a bit confused as to how that is limiting. You know, It seems to me like anybody can make a connection between what it is that they're talking about and the affairs in the city of Springfield.
It's very broad.
Very similar to public speak.
You're not wrong, Councilor. It's very broad. And that's kind of why I don't think the way we have it now is necessarily wrong at all.
Okay.
You know, to me, I read it as kind of, it's the councils that passed me very reasonable, the way I read the way Rule 3, the way we currently have it. So why not make that the pilot program Rule 2? And that's kind of the way I looked at it. Like, well, I didn't think it was broken, so I didn't fix it. But it is, you know, there are other options to do it. And maybe the way we're doing it now is the best way to do it. But I thought it was worth, if we're talking about the pilot program, this is the right time to have the conversation. Do we want to change anything, or do you want to leave it as is and see how it works inside the meetings?
And we haven't seen an issue thus far in terms of our public speak out, sort of being woven into a potential hearing. Like we haven't had too many issues in terms of public speak out,
I
right?
agree. I'm not aware of that coming up at all, really, Councilor. I mean, if it does, it's very, seems very rare.
Okay.
And I would expect that to be the case. Honestly, Councilor, I'm sort of in a way doing the worst case scenario stuff here. And that, as attorneys, as you know, like we sort of get stuck in that world sometimes where it's like, these are probably very remote things we're talking about, very remote. But yeah, it is something that we haven't had to deal with as a problem. So I wouldn't expect in the trial program it to rear its head all of a sudden. I think the only additional issue for the counselors is essentially the open meeting law aspect of it, which again, they're not allowed to participate in the current public speak out under the rule. So that's not
counselors.
Right. Yeah, they're not, there's no supposed to be back and forth during the public speak out, right? So it's not any different in the program. Now they're putting it inside the meeting. The only difference is if somebody does do it, if under the current rule, it's just a violation of the council rules. If they do it in the meeting, then it's an opening meeting law problem.
Yeah.
I mean, that's really the difference in when the timing of it happens, inside or outside the meeting.
Got it. So I'm just going to say one more point, and then I'm going to defer back to Madam President and then to Councilor Davila, who I know wants to speak on the matter. This did come up at one of the events we were at when we were running for city council. And really the crux of the reason as to why it came up for my colleagues on the council is because there was a level of frustration for people that were coming to public speak out and they were not seeing anyone present from the council, or seeing very few councilors who were present. And so one solution to that we thought would be to include public speak out as part of the regular meeting, because typically most folks are on time to the meeting. And we also, valued the fact that we wanted to have more counselors present for those individuals who are coming to speak before the body. I don't know if a rule change is something that we should entertained just for those counselors who don't want to come to public speak out or who choose not to come to public speak out. However, one of the main reasons why I wanted to see the adjustment was because what happens is we have, what I dislike is we have one or two individuals coming for public speak out starting at 6 o'clock. We hear them for 2 minutes, or in this case, 3 minutes, and now we're at 6:06. And then we got to wait 24 minutes to start our regular meeting. And I'm sitting here like, come on, like there's no reason why we shouldn't be able to expedite this and get the meeting started. So that was really the main reason why I wanted to see this as part of the meetings. And so with that said, I'll turn it over to Councilor Whitfield, followed by Councilor Davila, and we can go from there. Madam President.
Thank you, Mr. Chair. You said exactly what I was just about to say, but I am looking at Rule 3 since I've been looking at the rules so diligently lately. And it does say that all members of the council shall attend public speak out. And so that rule is stated. There may be other counselors should look at the rules as diligently as I am doing right now to make sure that they're doing the right thing, because it is in the rules that all counselors shall attend public speak out.
Thank you.
That's a good point, Madam President. That is in the rule. It is in the rule. You're correct.
It is in the rule, and it's something that we can actually, discuss or maybe put in a memo, Attorney Moore, that is part of the rule. And then we could try to see if people will start attending public speak out as part of the city council hearing. As part of the public speak out, time. And the reason that I brought it forward was for the same reason that Counselor Hurst mentioned. It was mentioned in a meeting that we were at in Forest Park, in another meeting, that counselors are not showing up and people are signing up and using their time to come down to talk about issues that are important to them, and counselors aren't showing up. So that's the reason that I wanted to pilot it, because I am listening to constituents and just trying to see if we can come up with a resolve.
Madam President, makes a lot of sense. I know, just doing the research on it, that that was a lot of the concerns of communities who did end up having it in the meetings, just like the chairman said. Increasing public participation, increasing counselor participation, and then efficiency in the meeting. Those were really the three. You hit the nail on the head. It's exactly right.
And if I'm someone who wants to engage with my counselors, if I know only one or two are going to show up, then I'm going to stop coming and probably spend my time doing something else. And so I can totally see why it makes sense to include it as part of public speak out. Although I think either way, whether this passes or not, we probably ought to remind folks about rule
mandatory
number 3
attendance,
and
yes.
what shall means, right?
Agreed.
Which I'm assuming it means necessary, must,
Required,
yes. All of the above. Councilor Davila.
Thank you, Mr. Chair. Thank you for your presentation, Attorney. And I do agree that this is a good start. It's important that we follow that we're diligent and that we follow the rules, Mr. Chair. That we all have to follow the rules as set forth. Couple clarifying questions for you, if I may.
sure.
So with regards to attendance, I agree 100% that we all should be here at the meeting or at the public speak out. That's what we were elected for. But to be clear, because now times have changed, are we talking about in-person attendance or are we talking about remote attendance? Because same thing for the regular meetings. In the regular meetings, the plethora of counselors that consistently come remotely, they're still considered present. Yes. So is a counselor remotely participating still technically present as we are now, if I'm not mistaken? So maybe the public might, I don't know, I'm just putting that out there so that we're clear and give that context of that conversation.
Yeah, so Councilor, I think when the council is authorized to have remote participation in meetings, the remote participation counts as attendance. So it's similar to like a quorum. You know, if you have members of the body that are appearing remotely, they still count towards the quorum, even though they're not physically at the location. And that law actually changed during COVID. When we first implemented the Zoom regulations during the initial stages of lockdown.
That was 2020, right?
Right, you had the regulation was still in place that a majority of the body had to physically be at the location and then others could be remote. And then there was sort of this very quick change made when people realized it's somewhat counterproductive to what we're trying to do for COVID protections to put 7 people in the room when we want 1 and then everybody else remote. So they changed it and those restrictions have continued. So if you're participating remotely, you are in attendance. It is as if you were in the room physically in your chair.
So to be clear, a counselor during public speak out
Can
who is
attend remotely.
remotely is present.
They would count for the purposes of the rule as far as I
Present.
understand it, yeah.
Okay. All right, so because I wonder if the public knows that.
Well, I
If
think
they're aware, and maybe we can do a better job at explaining that. I don't know.
yeah, I think the council, the issue is probably that the rule itself was written before that was contemplated as possible.
Anyway, no, I agree
You
with
know,
no, I agree with that.
Technology, like the
I
rule is
agree.
not kept up with technology necessarily, so attendance is a generic
Okay,
term for being present as counted by the.
I understand. So that was my first point. The second point is the councilor's response during this speak out. Are you saying that you got 24 minutes, which is essence, because 8 people times 3 is 24. We are not to ask questions, because even right now, even though I believe there has been clarifying questions that we can ask people
Yeah, so
during the speak out.
yeah, I'm not sure in the present rule, I don't have it in front of me whether participation is allowed. If it was in the meeting, the participation would not be allowed. You know, you'd be in a situation where they could discuss any city business and it might not be in an agenda. So as soon as the council starts speaking and its deliberation on something not on the agenda, it's my reference to the open meeting law is that exact point, right? So you wouldn't be able to ask a follow-up question. If it's something that's on the meeting agenda, I guess you could technically do that because it's on the meeting agenda and you have a place to speak about it. But if you'd have to be careful, and that's kind of where my self-policing comment comes in, like that, you got to be aware of what is and what's not on that meeting agenda if you're putting public speak out in the middle.
Okay.
So, you know, my recommendation would be have the policy have no participation during public speak out, because if there's something being said on an agenda item, just talk about it when the agenda item comes up. The public speak out can just be somebody speaking about it, and then when the time comes to the body to actually address it in order, it does, and then you can make whatever rebuttals need to be made. So I think non-participation during public speak out is important. You know, a lot of
That would be the cleanest.
Well, it is in a couple ways. You know, it helps us not get in trouble open meeting law wise potentially, but it's also in the spirit of what that is. You know, it goes as far back as like the founding of the Commonwealth and the country, where the government's not supposed to abridge in any way the speech. And that's sort of something I think all agree with and fundamentally believe in. So yeah, it kind of comes down to that, like, you know, steering the commentary or trying to, you know, and there's plenty of case law where there's even more egregious behavior of people trying to stop you from talking altogether or throwing people out of meetings in crazy situations. You know, even sort of like, you know, taking the public comment and asking questions and taking up the time that they have, even that's probably not advisable. You know, it's almost like free open forum to address your elected representatives, whatever you say you need to say. If it's city business, we'll allow it. Certain things we can't consider, and then the rest you can say whatever you want.
Right.
You know?
Thank you. Mr. Chair, I do have 2 more questions, but I want to double at the time. Or if you want to indulge me, or you want to.
So let's see if there are any other counselors that have any questions. And just my one comment on that before I lose my train of thought is that I think that ought to be the case for whether it's during the meeting or outside the meeting in terms of you know, not having that dialogue back and forth, because you ultimately take away from the other individuals who have signed up to speak. And so, you know, I'm not a big fan of it myself. And I think we've done a good job as a body over the course of the years. Counselor Bruce Click, if you have any comments, feel free to chime in at this time, or any questions.
No, I'm good, Chair. Thank you for that. I'm just listening, taking it all. Thank you so much.
Got you. Counselor Martin?
Sure. I kind of a question that kind of just went through my mind. If we if we did incorporate it within the actual meeting, is that when you said that we would have to, or we could, I don't wanna use the word limit, but then kind of like dictate what sort of topics people can speak out on, like, if we open it up to this, or if we incorporate it into the meeting, I don't wanna months later say, all right, well, now we can only talk about like city business, like, does that open that door?
No,
Does
I
that
think-
question make sense?
As it stands now, Counselor, that's sort of the standard we have, is that, our public speakouts are governed by, it should be city business, and it can't be something in a pending hearing. It's, in a nutshell, the way we have it right now. Putting it inside the meeting really changes the open meeting law part more than the constitutional part. The constitutional part is kind of always there. It gets heightened when you make it a part of your regular meeting, because you're inviting them onto your agenda as the body. But the same concepts apply to that analysis. This open meeting law question is a little different. Once you put it on the regular agenda, then it becomes, the participation thing becomes less of a council rule being violated and more of a open meeting law violation, which the Councilor Hurst has been very, very good at. We've been very good about adhering to those rules over the years. As complicated as it can be with council, the way the business comes in very quickly. We've been very good about it. So does that answer the question?
Yes, no, it does, thank you.
Counselor Davila, Madam President Whitfield, sorry.
I have the rules in front of me, and I just wanted to read a couple of lines real quick. It says, only matters related to the affairs of the city of Springfield shall be addressed. No subject shall be addressed upon which a public hearing has been set in accordance with law or by vote of the council, nor shall the council be addressed upon any subject which has had a public hearing in accordance with law or by vote of the council and is waiting a final disposition. There are 3 minutes and all that. But it doesn't say we can't conversate on it, but I guess I would go with the rule that it could violate public meeting law and open meeting law in some way. And so we should err on the side of caution. Because what if someone does address a public hearing or something like that? Or something we vote on, so.
So
But I don't see anything that says we cannot talk.
Part of the current rule, yeah. I think
Thank
it's
you,
probably
Madam
right.
President.
Yeah.
Attorney, where I actually was wondering myself, I know we've always sort of tried to abide by it, but is that in the actual rules, or is the reason? What is
Yeah,
the reasoning?
I don't think it's in there because it doesn't have, you don't have the open meeting law piece to it. I think that's what makes it different, is that when you put it on your meeting agenda, then it becomes potentially open meeting law violation, whereas when it's before the meeting, it's not considered that. And that's, I mean, it's usually good policy, Madam President, Mr. Chair, like as you're referencing that we allow the public to speak and sort of uninterrupted. But I think when it becomes a part of the regular meeting, it becomes important to think about participation. I did see in other communities, I'm trying to remember if I have in my notes which one of them. I can certainly let you guys know. I can figure out where it was. They had a discussion about this issue, about specifically that participation. They were worried would violate open meeting law. They had it on their regular agenda. And it was one of the cities or towns. But it made sense to me the way they were couching it, is that, it's a bigger issue when you're making it on your meeting agenda. And now you have a set number of agenda items. Open meeting law could be anything, because it could be anything in the affairs of the city. Participation by the council should be sort of kind of prohibited. And then as the meeting carries on, they can discuss anything else that comes up that's on the agenda, of course.
Does that answer your question, Madam President, or?
Oh, yeah, no, I just wanted to read what was in the rules and orders of the city council. But yes, and shall generally means required, not optional. Shall is like a mandatory language, so we can just reiterate that via memo, Attorney Moore, if we can send a little memo on what that means, so then we can just move forward as we've been. I don't want to risk open meeting law rules, adding this to the regular meeting, but it does say shall.
I'm sorry, Madam President, what says shall?
The rule says all counselors shall attend public speak out. And I looked up shall, and it kind of means required,
Yeah.
mandatory, obligated.
Got it. So
Yeah.
before I turn it over to Councilor Davila, my recommendation, Attorney Moore, would be to highlight in this order the fact and make it very clear that there will be no dialogue or questions asked by the council to those individuals during public speak out. Just so that people are clear and maybe you say for purposes of not violating the open meeting law. Whereas if we, and hopefully you'll be present when we bring this to the full body to make that distinction in the event that that weighs on whether folks want to do this or not.
Yeah,
I'm not over.
That makes sense, guys. Yeah. When do you guys anticipate having it back on?
I mean,
March is
my
March.
thought is March 2nd.
Yeah, okay.
You know, I mean, at least bring it up for,
I'm pretty sure I'm around. I could probably make that meeting. Yeah.
that would be
Schedule me,
great.
pencil me in to be there, and then I'll help you guys out, sure.
Much appreciated, Attorney.
No, right, because it's a strange issue. It's a little nuanced of like the placement from point A to point B and what that changes. So
For sure, and that may dictate where folks, where folks side in terms of their vote. So I think it's important for you to
Happy
be
to help.
present. Councilor Davila, sorry.
Thank you, Mr. Chair. I think, actually, I got two suggestions on the question. I think that's a good point about the idea of a memo so that we're on the same page. However, I will encourage you to perhaps, and I'm thinking of the governance order because as we all know, after COVID, everything changed, right? So now being remote is equals present, as you stated a little while.
Yes.
So I will also include that remote participation equals present, because now we're in a situation in which, if for whatever reason a councilor is participating remote, people are going to say he's not present when he is present, as defined by what's the word I'm looking for? Governance order / law. I'm not sure what's the word to use, but that being remote equals present. So that's one. Two, regarding the issue of time, I think perhaps, and I don't know exactly what's the best way to do this, Mr. Chair, but I think we need to give some leeway to the president so that if there is less than 8 speakers, that is clear that if the president chooses, that person may or may not get extra time divided equally. Because I don't see that here. When I read this, it doesn't jump out to me. This is 8 people, that's it. But if you got 2, I think the president should have the latitude if the president chooses to allow extra time divided equally. Or we may just choose to say we're going to move forward to the meeting. My esteemed colleague here alluded so that if it's the will, we only got 2 people, and after 2 people, we want to 3 minutes, we want to move on. Fine, but otherwise, I'm looking at it. We should try to give the people the best opportunity to address their goal.
Council, it's a good topic for March 2nd debate, for the deliberation of the body. I think that's a good, one of the subjects you should probably talk about is that.
Okay, all right. Fair point. Now, my last question, Mr. Chair, is the 90 days, the actual
I picked that number. Did I pick that number?
No, I picked
That was the original draft. I don't know.
Yeah, I picked that number.
I actually think
Seems like a good amount of time.
I actually think 90 days is a very good number, a very decent number. How do we measure effectiveness? What are the parameters to say this is effective, this is not effective? And who gets to make that decision?
No, I think that's probably, I hate to say it, but probably also a good topic discussion for the full body. It's something that, maybe the committee now wants to discuss a little bit, but I think all the councils would probably want to weigh in on what they think they want to measure, how they want to measure success in the context of this. I would propose and suggest that the body as a whole would probably come to a consensus of how it's working. It seems like it'd probably be pretty obvious if it has no effect, it has some effect at all. Counselors have been here a while and counselors knew, but I mean, I'm sure it's going to be pretty straightforward determining whether we're getting people at the meetings or not, but maybe not. I could be wrong.
My thought, Attorney Moore, and Councilor Davila, is that after 90 days, we bring it to a vote. And we voted to make it as part of our regular rules, or we vote to go back to normal, and how we had it before. And so that will determine whether folks think it's effective or whether they think it's not effective. You certainly can have debate on it, but I mean, at the end of it, how long are we gonna have a pilot for? I mean, we're gonna be discussing rules again in another in a few more months after the 90
Yeah,
days.
I have no personal opinion on that per se, but it's something that I think,
Yeah,
we're talking about making a decision, but we need to have some sort of parameters and ultimately who's gonna make that decision.
Yeah, council, you could have the council office sort of, or the clerk's office catalog the number of signups on, the 4 or 5 months before the pilot versus the 3 months of the pilot and do a comparison. It wouldn't tell you everything, but it's probably the only data you're gonna get is that, that's only raw data I can think of.
All right, thank you, Tony. Thank you, Mr. Chair.
are there any other questions from the council? Is there anything on here that we would like to vote to add? I mean, I know we talked about highlighting, including the fact that we should make sure that the counselors know that there is no dialogue. Should we vote on that amendment to the order so that we can have it included as part of this for the regular meeting?
It makes sense procedurally, Counselor, for sure. If this subcommittee thinks that's a good idea, then absolutely. And I'll put the language together for the body.
I'll defer to Attorney Moore, but I think
Sure.
the gist of, go ahead.
So essentially, it's an amendment to add language to section 4, which is the section that includes the participation element. That the counselors are not engaged in any dialogue or ask questions of the public speakers during the speak out, and that this is out of concern for compliance with the Massachusetts open meeting law. And I'll put in the citation for the law. But that's essentially what we're talking about.
Yeah.
It's making it clearer that's essentially what we're talking about in the vein of participation.
I think it's a great addition.
Yeah, I second that. Is that a motion? Or you can make a motion?
Yeah, I love when he,
I'll make a motion to add to section 4 regarding the scope of remarks, the amendment as stated by Attorney
Yeah.
Moore. Would you like to restate one more time the motion with clarity?
Sure,
Do you
yeah.
remember?
Sure. So in the vein of participation, that the counselors shall refrain from engaging in any dialogue or asking any questions of the speakers during public speak out. And then this is out of concern for compliance with the Massachusetts open meeting law.
Gotcha.
And again, I'll draft up language to provide to the chairman to put on so we can have an amended order for council.
so there's an amendment on the floor made by Councilor Davila,
Second the motion.
seconded by Councilor Martin. Excuse me, all in favor, say aye, of the amendment, say aye.
Aye.
Aye. You guys have it. Is there anything else that folks want to add that you think we might be able to vote on? Yes.
Just, Council, I just want to say, I'll put together a memorandum of like kind of Council's talking about that gives a background on this and kind of addresses some points here, including the one Madam President was asking for. I'll put that together with the amendment. So I'll send both at the same time. So everybody has it.
Sounds good.
I just think, if I may.
Yeah.
I just think perhaps to give us as much of a clear document to our beloved colleagues once we get to the floor. I think perhaps, and I open this conversation, if I may, should we add a motion to clarify that if we have less than 8 speakers, the president has the latitude to allow to divide the time accordingly, equally as those members present. I would love to hear what, I know we could talk about this in the meeting as you suggested, Attorney, but perhaps for clean purposes, maybe we should present that for them.
Something that just kind of
Councilor Martin.
excuse me.
No, you're fine.
Something that kind of came to my mind too is when I signed up for a number of speak outs this last summer. I think I had the deadline, was it like the Friday before the Monday? Is it maybe should we incorporate some language in there about like, deadlines to speak or anything like that? Like, I mean.
So I think you raise a very valid point, Councilor Martin, that slipped by me. Attorney Moore, are the people signing up for public speak out held to the same standard as folks putting agenda items on the actual agenda? And I know when I was present, I thought it was Wednesday at 12, but kind of had till Thursday. I don't know if it's 36 hours before the meeting, but what does the deadline have to change? I know we were normally Friday at 12 o'clock was our normal deadline.
For the public speak out
For the
sign.
public speak out
Yeah,
sign.
yeah, that was my
And
understanding as
so-
well, historically, right?
Yeah.
Counselor, my understanding is if it's on the meeting agenda and it just says public speak out, that's all it needs to say. Doesn't need to say who's speaking or what about.
Okay.
I think our sign up rules are internal. I'd have to verify that. I really don't know the answer to that,
Okay.
but I would assume that they're internal rules of the city.
I like it. That would keep things the same and
I can certainly add that too. Yeah, that's.
no, I don't think you, I'll defer to you all if you want to
I
add.
just have a quick question. When you said the internal, my understanding is that even now, Mr. Chair, people have until the day off.
To sign up for public speak out.
Yeah, but I'm not sure what the cutoff is.
How about I look this up specifically and get you guys a real answer? Because I don't know the answer to this, yeah.
From my experience, I believe it was that previous Friday.
I always thought it was the Friday before the Monday, and this is years and years and years ago when I was counsel to council, but I don't know where it comes from, council, to be honest.
Yeah,
I don't know if that's a policy in the clerk's
Yeah,
department or it's something that
yeah.
they've had in place for a while.
I think Council Martin brings a great point. Kudos to you.
Thank you.
Personally, I feel that people should be allowed as much, the public, as much latitude to sign up so they can address their government. And so that's my opinion right now. But again, I just want to restate, should we, the scope of remark, the speaker limits, should we add something in there about, because we didn't come to a consensus, I think. Should we clarify that if we have less than 8 minutes, the person has the latitude to, or
I don't mind giving.
divide, or do we just move on to the regular meeting? I don't know.
Yeah,
I don't mind giving the latitude to the president.
So in that case, I make a motion that we put my glasses on, Mr. Chair.
Hold on, because I got something to say on that, because I have seen past presidents give people in public speak out more time if they're, I have also seen them allow people that didn't sign up to speak, because other participants didn't show up, or someone might stand up and say, I'm here for someone else. I mean, it just happened in the last public speak out. So
That's a fair point.
Hold on. I think, Madam.
I think the
Uh,
president
Madam
may,
President.
I'm sorry. I think
Go
the
ahead.
president may already have the ability to do that.
So is that your question? Does the president have the latitude to
Yes.
dictate whether folks can have additional time? Attorney Moore, I'll defer to you. It always seems to me like the president, within reason, has some latitude. In terms of letting folks speak who have not signed up, it would seem to me that there ought not be any latitude with respect to that. But I don't know what the internal rules are. And so I do think that we need some clarity prior to next meeting, Attorney Moore, on exactly what the internal rules are in terms of timing for public speak out.
Yeah, that's very much what I was thinking, Counselor.
Okay.
Yeah, I wanna look at all this to make sure I understand it right. I think you're probably right that I know the president has latitude and discretion. And I've seen many times the president of the body allow someone a little longer to speak if they need to finish something that's complicated. In the context of public speak out, it's sort of this first come, first serve thing. So if there's a bunch of people trying to speak and the president's only gonna pick one who's not on the list, I can see that being a problem. If there's only one speaker, but somebody shows up late and is not on the list, the president has the authority to recognize anybody to speak. Only the president has the authority to allow someone to speak. So you could make the argument that the president already has the authority to say, I'm gonna allow you to speak and address the body now, please do. And then you're limited to 5 minutes. I could absolutely see the president having that authority now. But I will get a better answer as to public speak out specifically in the context of what we're talking about. It's a good question.
Councilor Davila.
Thank you, Mr. Chair. Mr. Chair, I restate that I believe that the people should have as much of opportunity to address the government. And so this is pretty clear cut as I see it here, as it's written, 8 speakers, 3 minutes. But we don't live in a perfect world. Okay, we could have 20 people. We can have that want to speak. We have 1, 2 people that want to speak. So what I'm saying is that I do believe that we should just make it clear that the president has the latitude, according how a president sees as fit, to divide the time equally among those present. I also think that's a great point, that if somebody shows up that was not on the list, I personally think that person, if we don't have 8 people that didn't sign up, I don't see why they shouldn't be allowed.
Yeah, I don't think they have a right to speak in public speak out. Yeah, I think the president.
But what I'm saying, I understand that, but what I'm saying is, I believe, should give the people the benefit of the doubt. And I don't see that, I'm okay with that personally. Somebody who's didn't sign up and wants to speak, me personally, I'm okay with that, but I will, you guys are smarter than me, or at least I think you guys are. I will, would love to hear what, my beloved colleagues will have to say.
Yeah, sometimes that can get long too, Councilor Davila.
Mhm.
So my other thought is that if we, if we can't hash it out here in terms of what it is that we think should happen, then maybe we might want to think about having another quick meeting on this prior to
Clarification.
sending it to the
Are you
bottom.
talking about allowing the people who doesn't show up to speak, or are you talking about giving the person the latitude to divide the time unless we have less than 8 people?
I think to make it easy, we ought to give the president the latitude on all of it. I also, my thing is, I wasn't a big fan of the 8 speakers. My thought is that you go until you reach your 30-minute limit. If that's 20 speakers, fine. If that's 6 speakers, fine. But at that 30-minute mark, I think we need to be clear that we need to move on. And so I'm not so sure that is highlighted in number 3 either. But I think to Councilor Davila's point, maybe giving some deference in terms of how the president breaks down, or some latitude to the president in terms of how she breaks down either the 3 minutes or the number of speakers or the amount of time each speaker has, that seems to make sense to me. So if I'm gonna come right to you, Madam President. So if you all are okay with it, then maybe we can give Attorney Moore the ability to just draft some language with that intent in mind.
Yeah, I have something in mind. Let's put something simple together and it'll probably solve the problem.
All right, Councilor Whitfield.
Yeah, I was gonna say, give the president the latitude. I think presidents have looked at how many people show up and give them more time. If there's no one else to speak. And the reason that it's no more than 10 should speak during the public speak out is so that the public speak out does not go into the regular meeting. So we don't want to have to start our regular meetings late because more people are signed up than 10 times 3 is 30. So 30 minutes for public speak out altogether. And that's the reason that there's a cap on 10 speakers.
Not a problem. I see 8 here.
Maybe 8, because some people speak longer. Some people speak longer. So just to be on the safe side, we could change it to 10, but we don't want to run the risk of our meetings going longer either.
I don't need to get caught up in the weeds. I think I'll defer to you and Attorney Moore, and we can certainly have any further discussion. I won't raise it come March 2nd. I think it's fine. I think my only the only thing with me was that if there may be some people that speak for a minute, right? And then they're done. But again, I think we're in the weeds, 8 people. That's fine. Dividing the time up, that's fine. I'm not at it. That's not why I would vote against this, or for it for that matter. Anybody else? Council Whitfield, I still see your hand up.
Oh, no, I'm
Oh.
done.
I just want to be clear,
Yeah.
so the plan is for Attorney Moore to draft up a updated version with the items of the letter to the president, and what else, Attorney?
I'm gonna research the timing and the deadlines for the sign up and for who can get onto the speak out sheet, and I'm gonna add the language that the chairman asked about for clarification about the dialogue and questions from the counselors based on our open meeting law compliance.
Okay.
So I'm gonna make those amendments.
Councilor Martin.
I just want to make a quick comment. It doesn't need to be resolved, or, we don't want to add anything more to Attorney Moore's work. But something that just kind of like brought past my mind, I want to raise it with my colleagues is under the scope of remarks, and obviously like, affairs, regulating the comments to the affairs of the city of Springfield exclusively. Something that I just realized, the last public speak out, for example, most of us signed on to it, was an issue regarding the state, which I thought was an important issue. It affects a lot of people of Springfield. So there is that, commingling, but technically I think it was a state issue. So I'm wondering, should we adjust the language so it involves a broader scope? Because I think it was important. I liked Heather's comments a lot, and I'm glad Heather came and spoke on that issue. And I wouldn't want to limit, similar discussions based off that. Not that we I don't think ever enforced against that, but just clarify, clarify the language.
I think to Councilor Martin's point, we maybe it's a bit ambiguous. And maybe we want to find a way to
Did you
broaden
look outside?
a bit, although I believe that anything can constitute the affairs of the city of Springfield, even what Heather brought before us, as there were folks in Springfield who were impacted.
Correct.
But if there's a way in which you see, in which we can come up with language that is a bit broader than affairs of the city of Springfield, then we'll take it.
I agree, Councilor. It's a good broad way to do it as we have it, but maybe there's a way to make it slightly broader to address the concerns I think we talked about. Yeah.
Right. I don't know if that's like too much of like threading the needle with it.
No,
just like, just something that.
It could be a slightly expanded language. Let me think about it. We can come up with something.
Yeah.
It's probably something straightforward to add an and another part or something into it.
Yeah.
I'll figure something out.
I have to for my.
Yeah.
Councilor Martin, you just opened a whole can of worms. Because I think I understand the intent, and I agree with you 100%. In my humble time in the council, I've seen people talk about all kinds of stuff. Whether it's federal issues, whether it's international issues, where stuff that we really have no control power in the city council. You bring a good example of I believe you're talking about the GIC.
Correct.
Issue, which we all sign on. But I guess Attorney Moore, I don't have to have an answer now, but my first reaction is, and you're the guy to do this, not me. Are we limiting somebody's First Amendment speech? Also, I think we need to be careful with that, right? Because
That's right.
I don't know, you're the attorney, you will give us the legal basis.
Yeah, no, and I think I brought that up before in the same context of why they have it worded the way they do is I think that's just like close to the line as they could get. We're trying to keep their arms around public speak out, so it didn't get all out of hand. And it was more focused on Springfield business. I think that's where the language came from, and I think it's close, but as Councilor Hurst, it's very general. You connect almost anything to that. If there's residents in the city, you could say it's an affair of the city. There's residents who are from some country that are having a problem. They want us to talk about it. Well, they're residents of the city, so it is kind of affairs of the city. It could be stretched quite thin in my mind. Part of me wants to take the whole thing out, just eliminate that sentence and keep the stuff about special hearings in that language. But let me look at it with an eye towards just that idea, and I'll figure out if I can come up with something for you guys.
Thank you, Attorney Moore. I think this has been an extremely vibrant discussion. Thank you to my colleagues for being in attendance. I know we have a meeting that is going to take place right after this one. If we could have a motion that made by one of my colleagues that to advance this item to the regular agenda into the full body. Once Counselor Moore has made his amendments and or suggested changes. And so it can appear on the agenda and of this full Springfield City Council, so we can vote it up or down. It'd be greatly appreciated.
So moved.
Second.
All in favor?
Aye.
Aye.
Aye. Ayes have it.
Aye.
Mr. Chairman, I'll get to work. I
Appreciate you, Attorney Moore. Thank you for your time.
Thank you, Madam President. Thank you, counselors. Thank you, Mr. Chairman.
Thank you.
Good to see you.